Chris. Thanks, everyone, for being here. I'm going to be brief. First, I want to introduce the panelists very quickly. Is there anybody here who doesn't know Professor Blitz? Yeah, exactly.
I sound like I know myself.
So I want to tell you something you don't know about him. He's a very neat eater. And he teaches, everything, con law, evidence, leg reg, First Amendment, relevant here. And he's got an impressive resume and has published a zillion things and edits a series on law and neuroscience, and he got a JD and a PhD from the University of Chicago. All right. Professor Hsieh, perhaps not all of you know Professor Hsieh, but if you're interested in intellectual property law, he is your guy. He also teaches antitrust and leg reg. He's taught some very interesting courses for us, including law of blockchain. Is that right? Was it blockchain? Yep. And he's got a zillion degrees, like in engineering and stuff. And we're very happy to have him. This is only his, second year here. It's my third year, so I should know. Great. And then finally, we've got Elizabeth Isaac, who's one of our graduates. She is a director, shareholder, and registered patent attorney at Dunlap Codding. She's very active in intellectual property associations. She's a vice president for the Oklahoma Bar Association Intellectual Property section. And then she's very accomplished. She's been selected numerous times for Best Lawyers One to Watch in 2021, 2022, and 2023. So keep watching her. Okay, so on to today's stuff. We're really going to talk about two sets of two cases. First are the net choice cases. So both Florida and Texas passed very similar legislation regulating social media platforms. The 11th Circuit struck down much of Florida's law, basically on First Amendment grounds, while the 5th Circuit upheld much of it, in part because they said that the platforms are engaged, whoops, went too far. Oh, wow. No. Okay. The platforms are engaged in curation, that is, curating their sites, and that's not expressive speech, it's conduct. And so they could be, and then in addition, the Fifth Circuit held that they could be regulated like you regulate common carriers like phone companies or television stations. So both Florida, which lost in the 11th Circuit, and Net Choice, which lost in the Fifth Circuit, have filed petitions for cert. And I just want to add, in case there's any doubt as to why Florida and Texas are trying to regulate the big tech companies, Florida said that it was creating this law to punish the big tech oligarchs in Silicon Valley who silence conservative speech in favor of a radical leftist agenda. That's right. When you think radical leftist agenda, think Facebook. Right. What? Oh, right. Florida, sorry. Right, so the legislation at issue applies to platforms that do business in the state and have over 50 million users per month. It imposes significant disclosure obligations on those platforms, and it's enforced through the Attorney General, who has injunctive authority and can recover costs involved in litigation. But then really significantly, it also imposes damages of $10 per lawful message impeded, that is, a message that that they blocked, that they shouldn't have blocked, and $25,000 per day for any unlawful message received or lawful messages impeded. So it's the plaintiff's choice, right? So these are social media platforms that deal with millions or hundreds of millions of messages, and for each violation, they could face penalties of up to $25,000 a day. Florida cert petition, remember Florida lost, asks whether the First Amendment prohibits states from imposing time, place, and manner restrictions on social media companies, and whether the First Amendment prohibits states from requiring that social media companies notify users when they censor them. Censor is not a word that I would use in the context of anybody other than a state actor, but that's just me. And then they have more specific issues that I won't get into now because I know I'm short on time. Net Choice's petition, they seek cert on whether the First Amendment prohibits states from imposing content-based restrictions on platforms engaged in editorial choices. So that's the big question. Is this expressive speech or is it conduct? And whether the First Amendment prohibits states from burdening those editorial choices through what Net Choice, of course, calls onerous operational and disclosure requirements. So with that introduction, I'm going to yield to Professor Blitz, and then I'll be back to introduce the next two cases and Professor Hsieh and Ms. Isaacson. There you go. Oh, you've got your own timer.
I'll need it. Okay. Okay, I'm just going to say what he said, but with different slides. The problem, no, maybe a little bit more. The problem that I think is in back of these cases, the Net Choice cases, is this is a variation of a problem that the Supreme Court has struggled with for a long time, which is a problem of spaces for speech. And here's the problem. If the government could do what courts said it could do in the 19th century, which is just like you, when you're a homeowner, you can kick someone out if you don't like what they're saying. My seminar, I used the example of, you discover someone at your Super Bowl party is an Eagles fan. You didn't know that. You can ask them to leave. It's viewpoint discrimination, but that's good. It's your house. And it used to be the case that the government could do the same thing with its property. That is, it could kick someone out for saying things it didn't like. And then, in 1939, you got this opinion from Justice Roberts, not Chief Justice Roberts, Justice Owen Roberts, saying that government is more limited. In streets and parks, the streets and parks have been held in trust, and it makes sense, right? Otherwise, government can engage in censorship indirectly by saying, you can say whatever you want, just not anywhere in our streets, not anywhere in our parks, so where is it going to be from? Now, this is public forum doctrine. I don't have time to discuss that, but basically, public forum doctrine secures certain spaces for speech. Traditionally, first and foremost among them, streets and parks. But in the late 20th century, various commentators, and especially Justice Kennedy, started to say, if we protect streets and parks, we're not really protecting the key spaces for speech. So in 1997, he says it's mass and electronic media. Then, in a case in 2017, he says it's cyberspace. That's where, people don't take soapboxes to parks. That's not the spaces where people occur. So it's cyberspace, social media. So here's the problem. If it's not in streets and parks where you find listeners if you're a speaker, or you find speakers if you're a listener, it's in social media sites, there's a problem because the First Amendment doesn't protect, I'm going to use censorship by social media companies or by any private company. The First Amendment only applies to government, typically. Now, there's one exception. In 1946, there was a town owned by a company, and the court said, well, okay, this is a privately owned town, but you control the streets. You're like the government. You're doing what the government does. People there need access to streets if they're going to hear each other. You're essentially the government. Now, that strategy really hasn't been accepted by courts, although I'm going to argue it kind of has snuck in the back door. So what is? To the extent one wants to prevent social media companies or other private companies from controlling speech, you need legal speech protection sources outside the Constitution, outside the First Amendment. Like what? state constitutions. The California Constitution has a free speech protection that applies beyond just government, private entities, state statutes, maybe federal statutes. But there's a problem with that, or there's complexity there, right? And the complexity is this. So basically the strategy is these other non-US constitutional sources outside the First Amendment can provide speech protection vis-a-vis private entities. But here's the problem, or here's the complexity. If the private company that's being restricted by a state constitution speech protection or a state statute speech protection is an editor or some other kind of speaker, then it has its own First Amendment rights. And it can say, by requiring us to host speakers we don't want to host, you're violating our First Amendment rights. And in the 1974 case of Miami Herald versus Tornillo, that's exactly what happened. The newspaper won. The newspaper was subject to a right of reply law. It didn't want to allow Tornillo to publish a reply to a piece that had criticized him. And the court said, well, that's right. The newspaper cannot be forced to host this speech. On the other hand, if the private entity is a conduit, if it just provides infrastructure, just a space for speech, it's not actually a speaker itself, then the court said, in a case on the shopping center, you can't, if California forces you to tolerate speech, you have to tolerate it. And the shopping center in this case tried to compare itself to the newspaper in the previous case, and the Supreme Court said, but you're not. You're not editing. You're just, you have a brick and mortar space. For the most part, now you happen to care that someone is engaged in political expression, but you're not creating a speech product the way a newspaper is. So the background, and this extends to so-called common carriers, including phone companies. So although AT&T and Verizon, trying to remember which companies still are in existence, MCI, do you know MCI? Although, of course, they're important for communication, they're not speakers like a newspaper. They just lay down the wire. So they're subject to rules that prevent them from discriminating against speech. They can't make the claim that they're editors. So what are these, right? That's really the question at issue that the Fifth Circuit and 11th Circuit are differing over, right? Are social media entities editors or another kind of speaker, or are they conduits? And basically, the 11th Circuit, in reviewing this Florida law, said, we think it's an editor or speaker, right? We think they are curators. Social media companies are trying to create a particular type of speech product, and they're trying to promote various values and viewpoints. Social media's content moderation decisions, which is really what caused these states to try to restrict them, are closely analogous to editorial judgments. So they get First Amendment protection. And that's why what the 11th Circuit said is, by trying to override their content moderation decisions, you're interfering with their speech. You might not like the way they moderate content. Fine. Well, you can always encourage some other company to set up competition. But their content moderation, it's new high-tech moderation. It's a bit different from newspapers in that, you don't have review of every tweet, I don't think. Maybe since Elon Musk has taken over. But, generally people post tweets and then maybe tweets are identified that violate the user policy, then they're removed. But the 11th Circuit said it doesn't matter. It's still editorial judgment. They've never said anything goes. They've always excluded some speech. By contrast, the Fifth Circuit, in reviewing Texas's law, essentially said, no, they provide infrastructure which carries speech. It's a space it takes place on. In fact, said the Fifth Circuit, that's how they've promoted themselves, right, as this open town square that everybody can bring speech to. And then they've decided maybe to backtrack, but after, you know, inviting everybody in the world in. So they're more like the shopping center. Now, yeah, I know. And, you know, these are just, I don't have time to go through the quotes, but they sort of quote these social platforms as saying, we're not editors because there's certain benefits. They've told Congress their goal is to offer a platform for all, that to simply serve as conduits. So who should win this? I'm not going to tell you exactly, but let me make just a couple of points before my time is up. Oh, I thought I would, but I got cut off. So just a couple of points without the slides. One is that I think that to the extent the argument is from the Fifth Circuit that, well, you can't be an editor. You can't be exercising editorial judgment unless you do something really what a newspaper does, and before you print something, you review it. I think that's a hard argument to make. And I don't have slides, but I think there are other places where the idea that heavy use of algorithms or after-the-fact removal can't be editing, I think that's unlikely to win. That said, right, with my last 30 minutes? No, last 30 seconds. I think that really, if the Fifth Circuit's going to prevail, it's because although I said earlier that the Marsh versus Alabama idea of the company town is not really, they're not relying on this public function doctrine, that's what's behind it, though. The idea that, and really what with Justice Kennedy, that what streets and parks have now been, their function has been taken over by these private entities. And so there's a problem if the protection that people once got in streets and parks is suddenly gone. And my time is up, so anything else I'll reserve for comments.
Okay. Thank you, President. Wonderful. So now I'm going to introduce the next two cases. These are cases that the Supreme Court actually has already taken cert on, and they're very, very similar. Gonzalez v. Google. Here's the statute that's at issue. It's the notorious Communications Decency Act, Section 230C1, which basically says you can't sue social media platforms or other interactive computer services for stuff that they post by third parties. But in this case, it's pretty hair-raising, the facts, because Gonzalez's daughter was killed in an ISIS attack in Paris, and he alleges that Google, which owns YouTube, was recommending ISIS videos to users. And what do they mean by recommended? Well, it had an algorithm, and the algorithm was identifying people who would be interested in that content and was pushing that content and therefore radicalizing people. So he's contending, Mr. Gonzalez is contending that Google can be liable, not reliable, liable for its recommendations through its algorithm. And the issue on cert is whether the Section 230 should immunize them, even though they're making targeted recommendations. Then the related case is Tamna, and in Tamna, which I've lost my place. There it is. That isn't challenging the Section 230 of the Communications Decency Act. It's brought under the Anti-Terrorism Act, Section 2333, which makes it any national of the United States who is injured in an act of international terrorism may sue those responsible, but also any person who aids and abets by knowingly provided substantial assistance. And so Tamna's is a Jordanian citizen, or the survivor of a Jordanian citizen, killed in an ISIS attack in Istanbul. In the same Gonzalez case, the Ninth Circuit, where the Ninth Circuit said Gonzalez doesn't have a claim, the Ninth Circuit said, but there could be a claim against platforms for aiding and abetting, notwithstanding their immunity under the Communications Decency Act, right? And so now Twitter and the other social media platforms are challenging this, and the issue, as they put it, is whether Twitter can be held responsible for aiding and abetting an act of international terrorism, where two things they claim are true. One, like, they didn't meet the scienter requirement. They didn't knowingly aid and abet any action, and plaintiffs would concede this, there's no connection between this particular terror attack and anything that appeared on social media platforms. So with that, Professor Hsieh will talk about this in general, and then Ms. Isaacson will talk about specifically the IP issues raised by these cases. All yours.
You get the borrow the clicker.
Right.
Thank you.
Like I'm sabotaging you already. Sorry.
I'll just run back and forth between the computer. So that was a really excellent overview of the facts from Professor Telman. And so, in contrast to maybe the net choice cases, the Google versus Gonzalez and the Tamna versus Twitter case, those cases are almost like mirror images of one another, because the Google and Twitter cases are really all about whether or not telling the platforms to thank you. Telling the platforms to basically take down more content, right? To take down content that would be considered dangerous, or something that if you take it down, you would prevent bad things from happening. And usually people are very sympathetic with this goal, because that effectively makes the internet a safer place and prevents things such as the tragedies that happen in both the Google and Twitter cases. In contrast with the net choice case, where that case is more about wanting platforms to step in and tolerate more harmful content, or more harmful or offensive speech than they're used to. And so that's typically been associated with more of a politically conservative viewpoint. So just a sort of maybe a high-level summary of what happened in Gonzalez versus Google was that the family of Nohemi Gonzalez alleged Google was complicit in a November 2015 ISIS attack in Paris that killed 130 people, among them Ms. Gonzalez. And the plaintiff submitted that the Google-owned service YouTube was used by ISIS to recruit and radicalize combatants in violation of the Anti-Terrorism Act, ATA, which is 18 U.S.C. 2333A, and the Justice Against Sponsors of Terrorism Act. And so there was advertising. Every time you go to YouTube, every time you watch a video, you'll see an ad, you'll see ads, but then after you complete a video, there'll be pointers or thumbnails heavily encouraging you to click on the next video. And so the allegation coming from the plaintiffs in this case was the fact that YouTube sold advertising on these ISIS videos and shared the revenue with ISIS. And so this was a ground that, this argument ground essentially asserted that YouTube and Google were providing material support to terrorists like ISIS. And the Ninth Circuit dismissed the suit, saying that Section 230 protected YouTube from liability because just because of the fact that even though the videos were produced by someone else, YouTube and Google should not be held liable. And that is almost the hallmark of many of the provisions within Section 230, as Professor Telman was just reviewing. And then, in contrast, the Google versus Gonzalez case was solely about the liability of whether or not platforms can be held liable under Section 230. But as Professor Telman was pointing out earlier, the Twitter versus Tamna case is instead it's all about secondary liability, and whether or not Twitter in this case should be held liable or culpable for distribution of ISIS material without editorial supervision. And Twitter, Google, Facebook, the question there was whether or not those companies aided and abetted ISIS's activity in violation of the ATA and JASTA. And so and so the lower courts never actually got to the issue of Section 230, but they stopped at that liability issue. And so as a result, I think they left the resolution of Section 230 to the Google versus Gonzalez case. And so, but both of them, pertain to the same issue as Professor Blitz, very clearly framed. Like, are platforms like YouTube and Facebook and Google and Twitter, are they considered, should they be held liable for their speech activity? And so this is like a tweet from Brandy Nonek saying that, so the Section 230 was actually passed in 1996. So for those of you who were around back then, you may recall that the AOL was all the rage, and the internet, we had to actually use phones to connect to the internet. There was like loud screeching noises. And so that was considered the internet, basically the predominant interactive computer service. And but compared to now, if you were to take a time machine and go back to 1996 and tell people that we have this thing called Facebook and it's like overthrowing elections, I think you'd be hard pressed to find anyone that would believe you. But in 1996, that was when Section 230 was enacted. And so you had companies like Prodigy and AOL, and they had bulletin boards that hosted information. But you look at Facebook, you look at Twitter, you look at Instagram, you look at all these platforms now that are completely different because they utilize these unique, specific algorithms that mine data collected from users, and they personalize these ranked news feeds, these recommendations of what video to watch next. And these are starkly different than maybe the more primitive bulletin boards that you would see on an AOL platform. And so after the passage of Section 230 in 1996, the main question is, do these algorithmic recommendations transform this protected interactive computer service, which Facebook, YouTube, all those companies are trying to qualify as, to an unprotected information content provider? And so all these companies are sort of backing up and trying to say, well, we have no other way to present this information to users. We have to use these recommendation algorithms because that's our way of organizing information, as Professor Blitz was mentioning earlier, the editorializing. And so the co-authors, though, there was like two senators that co-authored Section 230. They say that recommendation systems are direct descendants of content systems, but is that really the case? I mean, it's just really difficult to say. And this is an example of a YouTube video where if you click on it, there's an ad, but then these ads are fueled by this recommendation engine. And so there's a line in the Department of Justice brief that says, if YouTube had placed a selected ISIS video on a user's homepage alongside a message stating, you should watch this, that message would fall outside Section 230C1. And then, so encouraging a user to watch a selected video by placing it on the up next sidebar is conduct that's actually distinct from the video's publication. So if you're just hosting a video, it might be similar to the common carrier entity that Professor Blitz was mentioning earlier. But if you're actually actively encouraging someone to watch content, then you might be held implicit as being part of that speech. And so you also, the argument there is you should also be held liable and you should not be immune. And so that's the primary issue before the court, whether or not algorithmic promotion changes the nature of an online platform and thus its liability protection. And so it's sort of a very disturbing and scary thought that if the court answered that in the affirmative, then you would have a very drastically different internet on the YouTube. If you go on YouTube, you wouldn't find any even like remotely controversial video, and everything would be a lot safer. And then, is the internet still this metaphorical open public square? And the thing that distinguishes YouTube and Twitter and Facebook from a open public square is that it's a compensated service. And there's like this one prediction where Justice Clarence Thomas wrote in a 2021 case that we might want to pare back this immunity. And so that might be a somewhat indication of where the court may go. Another direction is that, as Professor Blitz was mentioning earlier, whether or not the common carrier, will these internet platforms be given the common carrier status. But Justice Kavanaugh, when he was a D.C. Circuit judge, sort of like dissented and thought differently, and he thought that, you know, these platforms should have their First Amendment rights, sort of like a pro-business view, and should not be forced to carry speech. So that would not be consistent with you know, this whole adoption of a common carrier identification. And there's very briefly, in the EU, they have a very comprehensive set of laws called the E-Directive, and there's a Digital Services Act that was an update to it. But it's really like onerous requirements forcing the companies to look at, to be transparent about the algorithms that they're using, and they have to, like, you know, produce the code or disclosures about how they're using these algorithms. And so it's just extremely difficult to implement, like in the US, because you run afoul of these First Amendment issues. And that is it. And these are really excellent articles for you to take a look at. And I will save the most interesting stuff for Elizabeth, because she'll be talking about IP.
No. Is it yours?
Is this like so?
I just don't want to drink it while I'm up there.
Right.
Okay, so I'm not sure about being the most interesting topic. Hello, good evening. My name is Elizabeth. I was once in your shoes, not in this building, but in the old building. Don't start my timer yet, because I'm just getting to know them. Okay, so I have a disclaimer. Do I need to lean in, or can you hear me? Okay. So, all whom to it may concern, my wife, Happle May, having left my bed and board, I will not be responsible for any debts incurred by her, nor should you construe these slides as legal advice or any opinions of my law firm, Dunlap Codding. All right, now that we got that out of the way. So I need to give a primer, because I don't know who all in here is familiar with intellectual property, who's taken intellectual property.
Yeah, many of these students are in my epi class right now. So
Oh, very good. So there's several areas of law that can be protected by intellectual property. A few are up here. You've got patents, copyrights, and trademark. A patent can protect software insofar as an applied algorithm that has some new and useful functionality. Okay, so kind of more of a broader than just the particular code. A copyright will protect written code, so written source code, and then trademarks protect brands. So just to set the stage a little bit, I'm primarily going to be talking about copyright, since, and thank you, Chris, for all of the briefs you gave us and summaries and stuff, and working with me on this, and this is kind of where Chris and I ended up. So, what's a copyright? A copyright is the right to exclude others from reproducing. Can you still hear me? Yeah. Okay, great. So I know this is awkward to lean in. Copying, publicly displaying, and modifying works. What is eligible for copyright protection? It's a 3-part test. The work's got to be independently created. You didn't copy it from someone else. There's got to be some originality or modicum of creativity, and it's fixed in a tangible medium. So I write a song, it's written on the piece of paper, it's fixed. And copyright law only protects the fruits of intellectual labor that are founded in the creative powers of the mind. So here are some examples of different types of works that are protected by copyright. I won't go through them all, but you'll notice that, as I mentioned earlier, software code is one of them. What's not protected by copyright? Facts, unless the author selects and arranges the facts in a particular way that the author may have a copyright in that selection and arrangement. And then there's another further list here that are also not protected by copyright. So the fact itself may not be protected by copyright, but the expression of a particular fact, whether it's through a compilation or certain selection and arrangement, can be protectable. This is from the Feist case, which you'll read about in your copyright
You all, we read
textbooks.
it yesterday, right? Covering yesterday.
So now we all need to take a big theoretical leap together, and let's pretend that the expression that's been alluded to by tonight, as Professor Blitz said, possibly the more boring side of the editorial discretion argument, let's pretend that expression in the copyright sense equals speech. So if expression is speech, who's talking, and who's the author, and who owns the expression? An author of a copyrighted work is the person who conceives and manifests the work. And copyright law is limited to original intellectual conceptions of the author. So, who's an author? Who's talking? Who's expressing? Who's engaging in speech? Well, the U.S. Copyright Office will only register original works of authorship if the author is a human being. So we have several examples that we've learned through over the years. I don't know. All right, I'm going without my notes. So we know that an author's not a monkey. We know that an author's not the Holy Spirit. We know that an author's not a machine. If you're familiar, there was a monkey selfie case a few years ago. Maybe it's been more than that. It feels like a few years ago to me, where the author argued, well, not the author, but the man who was working with the monkey argued that, well, he kind of set up the stage and he selected and arranged, where the monkey was, handed him the camera, set up the equipment, and the Copyright Office said no, and that case ended up settling. Monkey's not an author. Same with the Holy Spirit. People have applied for copyright and indicated that the Holy Spirit is the author, and the office says no. Also, an author is not a machine, which is in the Copyright Compendium, which is kind of our manual that we go to. So, taking a step back on all of us being authors, whenever we create a creative tweet, we write a poem and we tweet it out. So, I'm a human. My tweet is expressive and contains the modicum of creativity. I own the copyright to my tweet, right? So, is Twitter, by moderating my tweets, infringing me? Not when they censor me, when they moderate me. Yeah, but we all, by using these platforms, agree to certain terms of use. So as you know, even though Facebook will say, you own your intellectual property, and we're not giving an assignment to Facebook or Twitter, but we are giving them a license, and these licenses are very broad, and typically even say that they're perpetual. We're giving them a right to use, copy, reproduce, process, adapt, modify, publish, transmit, display, and distribute our content, and we're letting everyone else do the same thing. So we can't, get upset, I guess, maybe we can, if these contracts are unconscionable, but that's a whole nother topic. So what about going back to this, idea of editorial discretion? Is social media AI speaking? Well, what's a machine? According to the compendium, a machine's a mechanical process that operates randomly or automatically without any creative input or intervention from a human author. It's just an assisting instrument. And the compendium notes that the crucial question is whether the traditional elements of authorship in the work, such as selection and arrangement, were actually conceived and executed, not by a man, but by a machine. So we have this case, this author, I'm going to say his name is Taylor. So he is an inventor and he produces works. He's not only he developed an algorithm that the source code of the algorithm is protectable by copyright, right? And potentially by patent. But he used the algorithm that he developed to create some artwork. And he, in his copyright application for a recent entrance to paradise, he noted that the author was the creativity machine. He wasn't trying to hide the fact that the author was a machine, or the AI that produced this image. So the Copyright Office said, nope, machine's not an author, and he appealed to the Copyright Board, and they upheld the Copyright Examiner's refusal. This case is with the district court in Washington, D.C. right now, and Taylor's filed a motion for summary judgment just this month. And interestingly, he's not really arguing so much, his extent of authorship in creating the AI that created the work as when I read the MSJ yesterday. He's making a property type argument that this is a work for hire, and because the machine's working for him. Anyway, you'll have to check that out. So we'll be watching that case. So we're going back to if expression equals speech, and if it's not a machine because it's a man or woman or they have conception plus execution. So here's two different scenarios. Scenario number one. Jason Allen creates an AI-generated print that you see here on the right. He spends weeks honing his prompts, and he manually edits the finished piece. So, the blogosphere is saying, okay, well, given that extent of human contribution, that's where the courts will end up coming down on AI and who's doing the expressing with how involved is the human. Here's scenario two, which is kind of what we've been talking about tonight. A human developer creates a subjective algorithm that at least in the beginning that human had some thought and input, because the algorithm itself can be protected, and then the resulting AI moderates millions, we've heard, third-party expressions on an online platform. So this is the IP part of, what we came up with in terms of expression and speech, and I will leave it to you. Did I get 10 minutes or what?
Exactly. Okay, so now it's time to open up the floor to questions. Chris, do you have some in the...
I did just a second ago.
Thank you. Any questions, comments?
Who is that?
My credit should be on there. It's from Commons. Yeah. It's on my notes then. Yeah, no, it's no one I know. You can get images off of Wikimedia Commons, and then there's an attribution that you include. Anyway, as an IP lawyer, I'm definitely careful with what I put into my slides.
All right. Well, if nobody else has a question.
We have one.
Oh, we have one.
I'm just going to speak up from right here.
Okay.
Is okay with that? So for Professor Blitz, using the facts of the Twitter case, if held in Texas, wouldn't Twitter be forced to allow the terrorist content? Or do you think there would be an obscene exception?
For terrorism?
Yes.
Under obscenity? No. I mean, maybe possibly under incitement for some of the content, although I don't remember exactly what the content was, but I don't think, I mean, if it was...
The recruitment videos? Or,
Yeah. But I think, but they're going after, if it doesn't count as one of the categories that count as an exception to free speech, incitement or a true threat, if it does, then the government could go after it and wouldn't be violating the First Amendment. If it's not inside an exception, then I guess the question would be, under the Texas law, social media companies with 50 million plus are not allowed to engage in viewpoint discrimination. So if it's viewpoint discrimination, yeah, that would be at odds with the Texas law. So, but the question is whether or not it's an exception to free speech law, I think.
So then, if I could follow up on that, ISIS could be suing in Texas for $25,000 a day in damage for its promotional videos that are not quite incitement, correct?
Well, I don't think it's going to do that, but it's. I think if they come for the suit, they might get arrested for something else.
Activity.
But if it's viewpoint discrimination. Now, I think, one of the things that, you didn't give me time, you cut me off at 10 minutes.
12 minutes.
We have
One
no
of the
questions.
things that comes up in the case, and one of the things that the Fifth Circuit sort of emphasizes towards the beginning of its analysis, is that the Net Choice, the organization representing social media companies, is bringing a facial challenge rather than an as-applied challenge. So it's challenging the law before it's enforced. And so one of the things that the Fifth Circuit emphasized is that you face a higher threshold if you want a law invalidated as unconstitutional before it's even applied to anyone. And so there were some sort of horror story hypotheticals that the social media companies were talking about, the kinds of speech that they now exclude, various examples of hate speech. And one of the things the Fifth Circuit said is, okay, but they're hypotheticals. We're at the stage of a facial challenge. And we're not going to take time to sort of go in depth into that analysis. But I think that this is sort of one of the responses, is that, come back if you want when you have particular speech you think you're forced to host. Now, if it's an actual threat of violence, then I think it's quite clear that that's not something that a social media company would be required to carry.
One more question. So contextually, I think we'll ask this in reference to the whole world, but just how free is our speech in the United States in comparison to other modern countries? And that's for everybody. Anybody who has an opinion?
Want to start, Elizabeth?
No, thank you.
Tim?
That's a great question. And then, that example I was going over earlier about the laws in the EU. And I know it's hard, though. That's actually hard to think of a country that has more free speech protections, and maybe Professor Blitz might know better, but it's just, there's not it's like the First Amendment here, right? It's number one. It's no other higher amendment. And so I feel when you're talking about the highest form of law in the land, the Constitution, and it's the most prioritized here, and it'd be really difficult to find, especially contrasting it with a country like China, for example, where it's maybe like the polar opposite, and maybe you have like sort of a spectrum in between where countries sort of fall on. But as you saw with the EU laws, there might be similar. I mean, like, it might not be as pervasive as the laws, the First Amendment in the U.S., but they do have some type of free speech protections. But it's just the challenges of trying to come up with a framework to regulate and say, well, this might be offensive or harmful or dangerous, but where do you draw the line? And this is a very challenging question that American courts have grappled with, ever since that they were formed. So, but perhaps Professor Blitz would offer some.
Yeah, I don't have much to add to that. I mean, the protection of the free speech protection in the U.S. is far from absolute. I mean, if you took constitutional law, you're taking constitutional law, you learn about various exceptions, about how the government can regulate speech in a content-neutral way or has much more leeway to do that. That said, in comparison to other countries, including countries in Europe and Canada, we have a much more libertarian style of speech protection, right? That is, I think those countries are relatively free, but they're more likely to engage in balancing and find, at least in certain cases, that the interest in freedom of speech is outweighed, say, by an interest in privacy, which isn't to say that the U.S. provides no protection in any case to privacy. It's just, I think there are fewer cases. In fact, not here and now, but in other circumstances, there are even certain cases. I'll name one. Snyder versus Phelps, where someone sued the Westboro Baptist Church for intentional infliction of emotional distress for protesting outside the funeral of their son, who had been killed in Iraq. And the U.S. Supreme Court ruled 8-1, with only Justice Alito dissenting, that the First Amendment allowed these people to picket the funeral. I think there's a good chance that in many other Western countries, that case would have come out the other way, out of respect for dignity or the feelings of the family at the funeral. So, yeah, I mean, you can, there's a lot to read if you're interested in comparative free speech law, but.
Go ahead.
Well, I can speak to comparative IP law, and we've seen that the UK and China and even Canada are more machine friendly than the US
Excellent.
when it comes to, copyright protection of an AI work.
We're allowing AI to be authors.
Mm-hmm.
Yeah.
Is that because the machines are already in control there?
Possibly.
Am I right in
Data.
remembering that the monkey case settled in part because while he couldn't win in the U.S., he had a chance in the U.K.? Oh, you don't know.
I don't know. Yeah.
I think that's. Anyway.
He moved.
My answer to the question is the U.S. is more protective of speech than any other country, and some of our First Amendment is dumb. Like money is speech, that's dumb. Commercial speech doctrine, that's dumb and made up. And lying, constitutional protections for lying, that's often dumb. So
I don't agree with all that.
yeah.
And he has the right to say that.
But yeah, exactly. He hired me. So other questions?
Professor.
Yeah.
Question for Professor Blitz. So in the Google and Twitter case, it seems like they're one of the things at issue is whether or not the social media companies are liable for failing to censor, whereas in the other two sets of cases, it seems like they're censoring too much. And I was wondering what your thoughts on that and how you think the court will dance around that.
So wait, in the net choice cases, the question is whether they're censoring too much, or I just want to.
Yeah, yes, censoring too much.
And in Google versus Gonzalez,
Yeah,
you're saying that the
they're
problem
Not
is
censoring enough.
Yeah, could there?
They got to go farther.
Yeah, they're trying to
Yeah.
be, the plaintiffs are trying to hold them
Yeah,
liable.
they're like mirror
for
images and-
not censoring enough.
Right, and I think, one of the things that's going on though is that feel free to jump in. Google versus Gonzalez, I think the idea is that the theory is that if something that Google is doing isn't protected by Section 230, 47 U.S.C. 230, it's also not protected by the First Amendment. If for instance it constitutes aiding and abetting, I forget exactly what the statute
Right.
said, that wouldn't be protected speech. And, so it's, I guess, conceivable that Google or some other internet company would say, but what we are being forced to do by the states, by Texas and Florida, is protected speech, or we have protection against being compelled to engage in speech or host speech we don't want to host. And so conceivably, even if Google were to lose ultimately, in that case, it and other platforms could still win in the net choice cases. Or they could lose, but on a different basis. That, in the Fifth Circuit's view, their content moderation just isn't speech. It's not editing of the kind the newspaper is doing. So I'm not sure. I'm trying to think out loud, but I'm not sure. It may be that taking one position in one case commits you to
Right.
certain positions in the other case, but I think, right now you can be for one case coming out in favor of Google and another case coming out against the internet company.
And I think strategically too, I feel that the Supreme Court deliberately set up the Google Twitter cases first, because you're dealing with a unique type of speech where it's the underlying, the content, there's an underlying law, right? The Anti-Terrorism Act. It is legal for that reason. And then you look at other examples like copyright violations, right? Where Elizabeth was talking about, where you're on YouTube, and then as soon as someone posts some pirated video, it's gone the next, like in an hour, right? The DMCA, and like it's taken down. And then anything like, you know, child abuse, child pornography, that's taken down instantly, because like there's no dispute where as to like, okay, that's dangerous. And I guess in the example of copyright, there's a lot of people, it's like really annoying for lawyers, but they also think that, yeah, that's also something that we value as Americans, and we should not have, you know, like pirated content out there. But then when you get to terrorism, it's like, okay, any type of content about ISIS, but then you sort of get into a slippery slope of regulating content that has to do with the Middle East, or, you know, terrorism in general, and it starts to encompass this really broad category of anything to do with, you know, like geopolitics or anything in that area, people speaking a certain language, and that becomes, you know, you start to have the danger of overly regulating speech. And I think like and then and you know, for net choice, it's a type of speech that involves, you know, political speech, where you have like two candidates, and you have like arguably some candidate says something about COVID misinformation, and then one side might find that despicable, but the other side, you know, may find something that the other side said was despicable. And then what Professor Blitz was mentioning earlier about viewpoint neutral, like how do you like adopt a viewpoint neutral perspective? It's almost like a lot more difficult. So I feel they're almost trying to use like this terrorism related speech as a litmus test to see what happens and to further define the boundaries of Section 230, and then they'll go into, okay, we'll try to tackle like the more you know, this more difficult area of like political speech, and when you're trying to use it as like on because the net choice case was about like you know, the Google and the Twitter cases were all about like you should try to stop this speech, but then the net choice case was like, you guys can tolerate it more. I mean, like, come on, you like, it's not that bad. You can sort of like tolerate these controversial viewpoints that politicians are spouting. So
One more thing. So there's one point of overlap, though, between the two cases, is that I think the Fifth Circuit in particular emphasized that if we do agree with what platforms are frequently arguing about Section 230, which is that under the most robust form of Section 230, which is arguably the form we've had for a while, platforms or interactive computer services generally are not speakers, right? They're not treated as the publisher of any speech. If I post something horribly defamatory on them,
Why are you gesturing at me when
if I were to, yeah, I would then continue. If I were to sort of attack, if I were sort of to twist the view you just expressed, the First Amendment, it's on me, right? You can sue me for defamation, but
can't sue.
Google, Twitter, Facebook will invoke Section 230 and say it's not them, right? How are they to know I would do that? And in any case, they're immunized against it, because if you don't immunize internet companies, they can't offer the services they do. So what the Fifth Circuit is saying, well, if they're taking that position over and over and over again, it's not us, we're not the speaker, how do they suddenly claim they are the speaker, right? And that's, you know, there are possible responses. You could say that Twitter is saying that they're not the speaker of my post, but they're the speaker in the sense that they're choosing what to curate. And they're sorry that got in under their rules, or maybe until they applied their rules. But they're still not, it's not about whether or not they're engaged in any speech. They're just not liable for individual speakers.
How about, you know, those like icons at the bottom where you can choose whether or not you like or are happy or sad or angry? Isn't that like enabling the speaker to have a tool to express themselves that they wouldn't otherwise have? Like, if say Professor Telman posted something and then you did the angry face, or, you know, liked it or hearted it, you know, is that almost like
right? Well, there's a certain,
because Facebook is
you know
providing that tool.
You know the cases better than I do. There are certain circumstances where they become a publisher because they are a co-author of the speech, and then I think they can't invoke Section 230, right?
I think we've got some more questions. Michael?
For Jess and Professor Hsieh. So on the artwork, the AI derivatives and related therein, there is obviously like a substantial amount of effort to modify something. But in the art world, you can have someone sneeze on a piece of paper and that would qualify as art. They can take a picture of it and that could be copyrighted. So at what point is an AI generated thing, like, how do you think the Supreme Court's going to ultimately wrestle and grapple with the fact of what actually is a substantial amount? Because you can have like Salt Bay, I'm going to drop a piece of salt, modifying a steak from $50 to $800, or it could take someone hours upon hours to make an absolutely gorgeous plate, and that would be, in theory, I'll just say intellectual property. How do you think the court's going to grapple with that, the definition regarding AI derivative works and artists using therein, that whole substantial amount in order to get that protection on it?
Are you asking me or Professor Hsieh?
Both.
Oh, okay. I thought you said Professor Hsieh. I think, the sneezing on the napkin is one thing. Taking the picture of it takes it to another level. Just to speak to because at that point, you have an author who could hold the camera at a certain angle or whatever. I mean, there's something there when you take the picture. When the human, not the monkey, takes the picture. I don't know that it'll make it, eventually the Supreme Court may or may not deal with this. It may be dealt with at the Fed Circuit, who, deals with IP cases, and we're just dealing with a district court case right now. But I think given the language of that's guided us through case law and through the compendium, where the human also needs to be involved in the execution, that there's going to need to be a little bit more than just random automation. But I think, on the flip side, the argument in favor of some protection is that you created the AI that created the work, versus if you're just using AI that you did not create to generate something like through, I always forget the acronym, like the new
Davis?
tool everyone's
No.
using.
Oh, Midjourney?
Yeah,
ChatGPT?
yeah. So I didn't create that algorithm, whatever I spit out through it, some written text is not, I didn't have any involvement in it. Yeah. There are other examples, in the compendium of what constitutes a machine, or for example, changing a format of a particular work from we're using a computer to do that or something. I don't know that there's any derivative authorship there. The only when we're talking about a derivative work, the authorship's really only into the new things. So there's got to be something new there too. If you create a second edition of a book and you've already copyrighted the first edition, now you're going to go copyright the second edition, you're going to reference that prior edition, and the new work, the derivative work, is really only in the changes. So I probably kind of dance around that question quite a bit, but I think it's going to require some human intervention, but that's just where I'm landing on it.
Yeah, it's like, if you're a painter and you use a paintbrush, how much authorship are you giving to the paintbrush? What the tools, to the extent where you can argue that, for ChatGPT, and I thought the example you provided of the prompt that you give to Midjourney or whatever, that's
Right.
it's copyrightable, right? Because it's like a literary work. But then the art that's generated by the program, is that, is it like a paintbrush that a painter is using because it's a tool, or is it really the AI that's generating it? Because but for that copyrightable set of instructions, then that piece of art wouldn't exist, right? So it's almost like there's this inextricable tie between what the human author is inputting into a tool or AI, and then you're getting a piece of work that would not be possible unless both of them work together to create it, you know, so.
Yeah, I mean, the modicum of creativity is pretty darn low, but it's been brought up a lot at the Copyright Office recently, and not necessarily with AI, but with logos, because another way to protect an icon, a logo like the Nike swoosh or the McDonald's arches, is to get copyright protection, because you have another set, and you have another a piece of arsenal, potential statutory damages. And we've seen the Copyright Office coming down on those logos as not having enough creativity, which is a little ludicrous. And in terms of like how low the bar is, and the other place I've seen it is in areas where that may be not, you know, something that's not necessarily separable, which is, yeah, I don't know if you've gotten into that yet, but maybe something that's more appropriate for a design patent, and hitting the, instead of saying something's not separable, saying it's not reaching the modicum of creativity. I don't know. There's a lot of this stuff doesn't get out of the board. You know, somebody's got to go appeal it, and we're just on the verge right now.
Can I take another question? Go ahead.
Okay, so yeah, you said section 230, it became law in 96, so there were maybe 300,000 registered URLs in 96. It seems like the general purpose for the law was the free flow of information on the internet.
Right.
For that.
Mm-hmm.
You know, it served big tech well, you know, through the years, and you know, now we've got Google and Meta and Twitter tied up in litigation. We have Microsoft, who just doubled down on the investment. I think it was a $10 billion investment in Chat GTP, which is similar to like OpenAI, which is a basically, from what I understand, a program that will allow you to ask for an essay on intellectual property, and it provides an essay on intellectual property.
It's how I put together my presentation.
Right. So
Secret sauce.
So Google, here's my point. Google, you know, they built their empire on advertising sales, and Microsoft, from what I've read, made this move, this investment. I think Chat GTP is up to $29 billion, and they're burning through the money. I believe Microsoft's goal is to overtake Google and overtake the advertising revenue that Google has built by using free content, by the way, and including journalism. And, you know, do you think that the AI argument will have any type of impact on the Supreme Court's decision? Do you think they're going to set and lie in wait to see what happens with this investment that Microsoft just made? Will that have any bearing on their decision?
I'm not sure I understand. So what bearing would it have?
Just to see the outcome of the investment, and if Google, let's say, I think my point is, you know, it almost seems like it's a slap in the face with this investment that Microsoft recently made, while we've got the three other tech giants in court tied up in litigation. And it's almost like Microsoft is maybe just hedging their bets, because they know if the law does change, it's going to take some time to do so, and they've already, you know, made out like bandits.
And I think, I mean, maybe Shane's question is, and I think this, with respect to the Section 230 case, say the Supreme Court said, okay, too bad, internet platforms, you do have this duty to go in and regulate like this content, and you should be doing a better job. And so there'll be a sudden huge need for AI tools that will help them do it, and it's just more of a burden, more of a, you know.
Right, there's no, from understanding, there's no protection against copyright violation, right, by Section 230. And to me,
That's like, yeah, so there's an
This-
exception,
this
230 that
just
says
do-
like, you can't do something illegal. So
Right.
like copyright violation, that's illegal. Anti-terrorism act, that's illegal. I mean, like, that's on the issue right now, but like, you know, child porn, child abuse, like that's illegal.
right, so just one fact, right, is not a violation, or it's not a copyright.
Yeah.
The organization and the I guess, presentation of an author of a number of facts is copywritten. And it seems to me that this software, it crawls the internet and it acquires like these massive chunks of information that could be part of, most likely is part of a greater work,
Yeah.
maybe multiple greater works.
I do think that what is the output from, I cannot remember the name.
ChatGPT.
Why did they just come up with an easier name? Yeah, ChatGPT.
Al, Fred, or
What?
Al as an AI or something.
Yeah, I don't know, whatever. Yes, like that is a derivative work, but you know, for the author of a derivative work to have any sort of ownership in that derivative work, they first have to have permission to even exercise the modification in the first place. So, you know, Warner Brothers, was it Warner Brothers, turns, you know, Harry Potter into a movie. Well, there's got to be permission. Otherwise, it's just infringement. So this output is arguably infringing on crawling the internet because there's copyrighted works on the internet too. Though I can't just go copy. So
Right, so I guess my point is, I don't think we've seen anything like this. It's not really the argument with the two cases that we discussed today. It would be something new.
yeah, I mean, I'm not.
Well, there's actually,
Attack on another company.
well, there is a district court case that was filed, artists filed suit against Midjourney, DeviantArt, and, it was another like, one of those AI art generating programs, but exclusively for that, it was just copyright infringement, and so that's an IP issue, and I guess like, with respect to Section 230, maybe there's some overlap, but like you're just maybe talking, maybe it'd be awesome if that case went all the way up to the Supreme Court, but it was just filed in Southern District of New York just last week, so.
Mark, you wanted to
I
jump
think
in?
I got it now.
So ChatGPT, I think you could ask it for its nickname, and that'll make it easier. I think it goes by Hal. So
There you
if,
go.
if-
Hal is a perfect
right.
nickname.
So just to be clear, right, it's not a creation of a derivative work to emulate the style of someone else. So if a band writes a song that sounds very Beatlesque, that's not going to be enough for the Beatles to sue them, right? It just, that doesn't make it a derivative work.
I mean, well, yeah. I mean, you're getting into substantial similarity, but it doesn't just spit out facts. I mean, I guess so. If what you're taking is protectable, then there could be some copyright infringement. But if what ChatGPT is taking is only the
Wow.
facts from these, otherwise, the way that these my article on whatever I wrote in my own voice in a creative way, but if all it's crawling for is those facts, then sure. I mean, it's not.
Or certain word patterns, right? Just certain styles that's not necessarily going to be a derivative work.
I mean, it'd have to be like a case by case basis, and.
Well,
it'd be
we
pretty-
learned that yesterday in IP. Like, those of you there's several of you who are in my IP class. What cases did we read about? The phone book, and what was the other example involving the Westlaw case, right? It was just
Yes.
like the actual facts, but you have to meet that minimum creativity threshold and originality. What is part of originality that you need to prove? You need to prove a originator, right? An originator. So without that, but it's a low bar, but at the same time, arguably, like, I mean, yeah, like crawling words and putting them together, but there is that, almost like there is that really basic creativity in that it's stringing together something that like would meet that modicum of creativity that Elizabeth was pointing out in her slides.
Okay, can I take another question?
Yeah.
This is for Professor Telman and Professor Blitz. One of the hallmarks of American history, obviously, is the right of free contract. And with the Netflix's case of Google and the Twitter, how those go, and whether it's a common carrier or, excuse me, I've forgotten what the other specific treatment it may get. But the inclusion of scroll wrap, the development of contracting, the rights of parties, both company and consumer, because ultimately those platforms, if it's free, then you're the product. Do you think that the cases and where the Supreme Court might go is by allowing the idea of the moderation and how they treat that? Do you think it's going to ultimately play in greater to the contracting rights, how people get treated as a commodity? What are your thoughts?
Well, if it's about contracts,
If I go first, you're just going to tell them all the ways I'm wrong.
I mean, my instinct is to say that's not.
Deny it.
Just, I'll say something, then I'll say them really quickly.
Okay.
I think in both of these cases, the main argument that the platforms have is a First Amendment argument. They're also making, in the 11th Circuit, they also made a preemption argument, saying that Section 230 preempts the state law. But the 11th Circuit said it didn't really need to analyze that because there's a violation of First Amendment rights. But that's what the platforms have. I don't know, but Professor Telman can correct me now that you're going after me.
Right.
I would think that actually contract rights they're not an absolute barrier to the state coming in and saying, well, when you contract, right? We're not in the Lochner era anymore. So when you engage in a contract, you would do it subject to state law, including, right? If you're a common carrier, then you're really restricted in who you can say no to, and it's really if they say, well, because we're editors, we're just not the kind of entity that you can call a common carrier. But go ahead.
Thank you for your question. I'm actually working on a series of articles about the First Amendment and its interaction with contracts. And although I'm coming after him, I agree that contract rights have traditionally not had the same, have not been treated as robustly. When it's a battle between contracts and the First Amendment, it's rare that the court even pays any attention to contracts at all. But here, I think it's kind of hard to avoid that, you're in Twitter's living room. You're in Facebook's living room. They've invited you in, but they've told you that certain terms and conditions apply. And it seems to me those should be given some weight, not weight that would trump a First Amendment interest, but certainly some weight. But then I want to also circle back to how much I hate the First Amendment and how dumb our jurisprudence on it is, right? The court backs it through its sort of common, because they're making it all up, right? None of it has anything to do with what the First Amendment meant in 1789 or 1868. It's all 20th century invention. And then they do this common law constitutionalism stuff where the question is the internet more like a shopping mall or a newspaper? And if it's like a shopping mall, then they have to treat it one way. If it's like a newspaper, they have to treat it another way. And it's neither. Adjudicate the case before you, and only that case. And then you'll adjudicate other cases, and then there'll be a constellation of cases, and eventually we'll have some sense of how these things all play out. But don't try to analogize the internet to a shopping mall. That makes no sense, right? Dumb. All right. Are there any questions?
Just quickly in defense of both circuits.
I reserve 2 minutes for Sir reply.
I think it's somewhat uncharitable to say they're saying that, if you squint hard enough at Twitter, you'll start to see the shoe stores and, the bookstores, and it'll really be a shopping mall. I mean, there are elements of it. Or that it'll be I think the idea is they know it's different. If maybe I'm being too charitable. They know it's different. The question is, does it share with a newspaper what makes the newspaper an editor, even though it's clear it's operating in a very different way, right? Or does it share with a shopping mall? Or really, most of the discussion, the emphasis is on carriers of phone service. The fact that it's really just infrastructure, where they stand back and they've created a structure for speech, and then they're letting other people provide the speech. And that's the idea, right? If they try to stretch the analogy too far, then it becomes comical, right? I'd agree. Right. But I don't think that most of the analysis is doing that.
Right, but it's a reply, right? Here's where contracts come right back in, right? Because there's no other context in which you, before you use the phone company or before you enter a shopping mall, you agree to terms and conditions. And that, I think, is a crucial difference that the court will not pay any attention to, but I think, as a contracts guy, is really important.
No, sir, rebuttal, because we need more time.
All right. Well, thank you all for your attention. Thanks to the panelists.